Okay, I think we could start.
Then let us be about the people's business. Brian, do we have a quorum?
We do have a quorum.
Then I will gavel us in. First agenda item.
First agenda item is the minutes of the last meeting of the the August 18th meeting. It's Memorandum 2241. Staff has no proposed revisions to the minutes.
Any
Actually,
comments?
before we do that, let's take a moment for a disclosure by Commissioner Carryover.
Right.
Morning, everyone. Thank you very much. I just wanted to announce for the record that I recused myself from the closed session because that subject matter may have impacted a source of income to me. Thank you.
Okay, so thank you. That'll be noted in the minutes. Back to the minutes from the last meeting. It's memo 2241. No proposed changes. Does anyone have any changes they want to make? Okay.
Can I get a motion?
So move to approve.
Second?
Second.
From the
Okay, I'm
ambassador.
gonna
Been
call the
moved and
roll.
seconded.
In alphabetical order, Commissioner Carrillo,
Aye.
Carrion.
Aye.
I'm not going to call the names of members who are entirely absent from the meeting. Hebner,
Aye.
Jenkins.
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Minutes are approved. Thank you.
Next is administrative matters.
Yes, I'm going to start with the executive director's report. Well, a couple of things. One is today's meeting is likely to be pretty short. You recall that you reactivated this meeting date. I'm not sure about that. In any event, the meeting is going to be short. We haven't had a lot of time to prepare materials. The principal purpose was administrative to enable the closed session and the discussion of new topics, because legislation that authorized new topics has taken effect, and it would be worthwhile to formally authorize the staff to work on it. So that was the main purpose for today's meeting, but there is some substance that's been presented as well in a couple of our active studies. The main administrative point that I have to make is, unfortunately, we are still not yet able to fill our vacancy, that Barbara Gall's position. As I explained earlier, we had proposed reclassifying that position as well as a sort of a parallel companion position for the Committee on Revision of the Penal Code as assistant chief counsel positions, which would have about the same level of responsibility for legal work, but would also be supervisors, which would move the supervisory function closer to the supervised staff and relieve the management staff of supervisory duties. So that was the proposal, and we navigated the process to put it into proper form, working through DGS HR and Cal HR, but any reclassification requires the approval of the Department of Finance. So the proposals were submitted to the Department of Finance 2-3 months ago, and we're waiting for them to approve them. The holdup is, in broad terms, that those reclassifications have been sort of bundled with a proposed budget change relating to the Commission's organizational structure within state government that I talked about at the last meeting. And so because it's bundled, the reclassifications are on the same slow boat that the BCPs are on. This time of year, Department of Finance is enormously burdened with all of the budget change proposals from different agencies and working to finalize the governor's budget proposal for January. So they are heavily subscribed with other work, and this has gone into that pot. And so it's on the same timeline. I'm hoping that we might get some clarity towards the end of October. But I don't think there's much of a chance at all that the reclassifications will be approved before then. And until they are, we can't start filling positions. So we continue to limp along with a major vacancy. But hopefully early next year, we might be back to full staff. That's all I have to report for the executive director's report. Does anyone have any questions for me? Okay. That completes that. I think the next item is the commissioner suggestions. Can't hear you, Commissioner Carrillo.
Damn it. I had one for, I think Steve is the right person. Steve, did you get the email I sent you about the thing in the Chronicle? Is that within our mandate?
So I did get it. Thank you very much.
This is the thing about bees being fish.
Right. So there was a decision, just to fill everyone else in. There was a decision, I guess just a little bit of background. There is an unusual definition of the term fish in the existing Fish and Game Code, which includes a number of different types of animals, and that includes invertebrates. And invertebrates are not only aquatic invertebrates, but they can also be insects. Insects are invertebrates. There was a decision in the Third District Court of Appeal a while ago, considering whether certain bees should be protected under the Endangered Species Act. And the court ruled that because there was no clear intent otherwise, that it was appropriate for bees to be protected, because a bee is an invertebrate and the act protects all fish, and etc. So the Supreme Court took up a challenge to that ruling and decided yesterday that the ruling would stand. There were some comments. They only had 3 justices that commented, but they did not overturn the decision.
Yeah, the court actually didn't take it up on the merits. I think they denied the petition for review.
Yes, that's correct. I'm sorry. Yes, that's correct. But in denying the petition for review, they made a few comments suggesting perhaps there should be some consideration of revision of that definition. That is, Brian, I would probably defer to you, but that would very likely be a substantive change. And we have made an effort to not make substantive changes in this particular study.
I was just thinking that, we're studying Fish and Game right now, and this really seems to be something that cries out for a fix. And I'm just wondering if we're the right people to propose that fix.
I don't think we have authority. The authority we have on Fish and Game is to study whether the Fish and Game Code and related statutory law should be revised to improve its organization, clarify its meaning, resolve inconsistencies, eliminate unnecessary or obsolete provisions, standardize terminology, clarify program authority and funding sources, and make other minor improvements without making any significant substantive change to the effect of the law.
A couple of things in there sound like they could qualify.
No, but it's all qualified by the last limitation without making any significant substantive change to the law. So if we reverse to a Court of Appeal now, Supreme Court.
No, I wasn't suggesting that, but
revise the statute to codify the holding.
Yeah, that or short of that, at least send a smoke signal or like a telegram to the legislature.
Yeah.
There's got to be a way for us to be helpful here.
It'd be a really short email, to be or not to be.
Right. So good.
Yeah,
I want that in the minutes.
We looked at this issue early on in the Fish and Game study because this is not the first time that this has been a question. Decades ago, I think it was limited to an AG opinion, but I may be misremembering. There was a question raised about whether or not the California Endangered Species Act applied to butterflies. And the statute, by its terms, it is clear. It says fish includes invertebrates. And from a biological standpoint, fish does not include invertebrates, right? Crabs, shrimp, mollusks, they are not fish from a biological classification.
Yeah, the crustaceans.
Yeah, crustaceans, sure. I mean, but I'll bet you that courts would feel very comfortable saying that the California Endangered Species Act applies to shrimp or clams. But they aren't fish either, either in a colloquial or biological sense. I think the dissonance becomes uncomfortable when it extends to things that don't even live in the water, right? Like butterflies and bees. I mean, in that sense, slugs are fish, you know, in the middle of the Santa Cruz Mountains, a banana slug is a fish. You can legally define any term to mean anything you want it to mean. It doesn't have to make colloquial or biological sense to be a legal rule. And so if the courts just affirmed that they did a strict reading of the language and they said on its face, it means what it says. There is no ambiguity here. I don't know that there's a problem that needs to be solved. Like I said, we looked at this at the beginning of the study and we said, should we deal with this? And the commission concluded, no, we should not, because the problem is, the complicating problem is that there are hundreds of code sections in the Fish and Game Code that refer to fish. And it is not clear from context, as you look at any of those sections, whether the legislature intended for it to apply to invertebrates or not. Sometimes it seems obvious that they weren't thinking of butterflies. And so if we were to go in and cut that knot one way or the other, we would be potentially disrupting the meaning of hundreds of sections that it would be impossible for us to do a substantive analysis and evaluate whether or not they actually were meant to apply to invertebrates. And Fish and Game, when we raised this issue, agreed with us that it was better left alone because it's just a mess. I mean, certainly it's something that could be clarified. I think the court opinion is useful in that regard because now maybe the legislature will do its own review, maybe a piecemeal review, a cumulative sort of incrementalist approach to thinking about whether statutes are or are not intended to apply to invertebrates. But for us to say that it does or does not, I don't think there's any way for us to be confident that that would not change the meaning of dozens or hundreds of sections.
Yeah, I agree with you. And that also gets into the forbidden arena of a substantive change. But this also feels like something that, you know, A, we should be calling to the legislature's attention, and B, you know, providing the kind of expert recommendation or suggestion about how to go about fixing it that this commission is well suited to do. And I also feel like if the Chief Justice of California says somebody needs to look at this and fix this problem, we're hard pressed to just say, yeah, that's not our problem.
Well, we're not empowered to answer it.
Not answer it, but call it out to the legislature, perhaps in a comment.
I think our preliminary part in the tentative recommendation that we prepared acknowledged that we were leaving that conundrum unaddressed. I think so. I think if my memory serves, and maybe Steve can correct me, I think we did call it out as something that we left on the table because there's just no way for us to thread hundreds of needles on that issue. Really, it needs subject matter experts to do it if it's going to happen at all.
Jane has a comment, and then Rick.
Yeah, I was wondering if it would be appropriate for something to be mentioned as a comment to this study in terms of referencing that most recent decision and just saying it's not in the commission's purview, but it's come to our attention that these are particular issues that may want to be addressed in the future, whether by, you know, I mean, the verbiage would be, you know, up to you, but,
Yeah,
and
perfect.
maybe a way to sort of do what Commissioner Creo's trying to importantly discuss about having changes. Obviously, we can't do it, but it
But we can
also
flag it.
shows that we're cognizant of issues that surround this study.
I think, like I said, I think it was raised in the tentative. We can certainly update that discussion in the final to include the reference to the appellate decisions. And maybe add a little bit of more pointed commentary that here's why this is a problem and it was beyond our purview to fix it, because here's what it requires in order to be fixed.
Rick?
Yeah, that the last thing Brian was saying was what I was going to say. You know, court decision pointed out this potential disconnect from, you know, everybody's expectations. If you want to fix it, here's the kind of thing you would need to do to fix it.
The ambassador has his hand up.
Yeah, I support the idea of saying something in a comment. I would assume if we saw the newspaper article, people in the legislature saw the newspaper article. So I don't think we have a Paul Revere function here, since it's public information. I would be a little cautious about the note, though, because what we're really talking about is an ambiguity which either adds or removes endangered species from protection. So it's extremely difficult to say we're just doing a mechanical thing, because what we're doing is saying all of these endangered species are not protected because they don't have gills and swim in water. And I'm a little concerned about going too far in us appearing to say that there should be species removed from protection in California under the guise of simply aligning biology with legal terminology.
That's a good point. And I was thinking that, you know, it just needs to be pretty neutral. And I don't think it needs to be anything in terms of advocacy on the part of the commission, because then again, it'd start to look like we were asking for substantive change. I think.
Yeah, I agree with Jane. I think it's about flagging it and you know, looking like we read the newspaper and we acknowledge that there's a problem and maybe the legislature could look at it. Steve has his hand up.
I was just going to read to you what was stated in the tentative recommendation. It's one paragraph, and perhaps you want to add to it or use it as a base. There is one definition that is likely to be confusing in some situations. The existing definition of fish, which applies to the entire Fish and Game Code, includes animals that are not considered fish biologically, open paren, i.e. invertebrates and amphibians. And then a footnote just to the definition. It is not clear whether every use of that term is intended to have the defined meaning. Notwithstanding the potential source of confusion, the Commission is not recommending any change to the application of the definition. Making such a change would require a determination of legislative intention in hundreds of sections, which is not practicable in this study. So that's what we had in the tentative recommendation.
We could certainly update that to include in the footnote the references to these cases. Is there any other point that the commission would like to make in the narrative?
I think it's enough.
Okay.
I'm seeing shaking heads.
Yeah, and I would just add one thing. Thank you, Steve. I totally agree with Commissioner Huebner about the Endangered Species Act implications and the politics of this. And I kind of suspect that the California legislature is probably content with the broader construction of the definition. But it, as the language Steve just read, emphasizes, it's not just the Endangered Species Act, it's the entire Fish and Game Code. And so we would have to comb the entire code and look at every use of the word fish and try to somehow determine whether or not it was intended to apply to frogs and clams. You know, and I don't think that's practicable. So I think my recommendation would be that we supplement that language that was in the tentative recommendation with additional citations to the recent court decisions, but basically stick to the substantive tenor of what we've already said there.
That's fine.
I am going to call the roll on this, just because it is a commissioner decision that's going to be reflected in the minutes. So again, alphabetically, not calling absent members. Carrillo,
Aye.
Carrion,
Aye.
Ebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Thank you. Any other commissioner suggestions? Okay, hearing none. With your
Hey,
permission.
Sochi has something that looks like a hand up.
Okay.
What's that weird white thing?
I don't see it. It might just be her blurred background somehow. I don't
No,
know.
there's like a white hand. It's not the yellow I'm raising my hand. It's I've never seen that before. How'd you do that?
I don't see it.
I don't see it either.
Neither do I, but
It went away. Never mind.
okay.
Okay.
All right.
So with the chair's permission, I would move on to the new topics memo,
Proceed.
2242. And there are a couple of things at issue here. The more important and more substantive one is for the commission to decide on its work priorities for 2023. And then less important, and we'll take it up second, have a discussion about how I have restructured and simplified the format of the new topics memo. So starting with the substance, this is the process we use to decide what we're going to work on in the next year. It's always subject to modification if circumstances change, but this sets our agenda for 2023. And the way this memo is structured, it walks through first the currently active studies, then the pending legislative assignments, and then inactive studies that we've worked on recently, and then any proposals for new studies that we received in the last calendar year. That ordering is intentional. I think it reflects sort of the presumptive importance of those categories. So with active studies, it makes sense to complete the work. Legislative assignments, it makes sense to prioritize and take those up to the extent we can. Inactive studies, there's an argument for repose and a lower priority for things that we've set aside. And then new topic suggestions are always nice to do and always subordinate to all of our other priorities. So I'll just go through and touch briefly on these. Fish and game we were just talking about. I don't expect there to be very much work left in 2023. It is my hope, and I don't know, this hope may be dashed, but it's my hope that we can finish phase one this calendar year and put together a final recommendation for introduction and implementing legislation next year on the revisions in place that we are proposing in the phase one fish and game work. I do not see anyone from Fish and Game in the audience, but we need to talk to them about that. We need to find out, whether they have problems with that time frame. It may be that if the commission decides that there's too much of the remaining work that is still waiting for their blessing, and they are not able to provide that before the end of the year, you might decide that you want to wait and tease it out a few more months into 2023, but probably not much more than that. So I don't think that's a huge amount of work. Phase two, we decided already, I think at the last 2 meetings ago, to discontinue phase two, the reorganization of the Fish and Game Code. So that's done. There is, I think, a good argument for preparing a final report to the legislature to just explain the work we did and the arc that it followed and why we concluded against proposing legislation. That's something easily done, small amount of staff time. And if commissioners wind up being comfortable with the report, of small amount of meeting time too. So Fish and Game, a little bit of work in 2023, not much, which will be great. Emergency related reforms. This is the work that Kristen has been working on, and the commission decided earlier this year that it would hold off on making substantive reform proposals at the present because of concern that such proposals are already sort of pending before the legislature, and we didn't want to step on other people's reform proposals, even impliedly. So the commission decided to spend some time this year just surveying reactions to COVID and the emergency services statutes in other states and jurisdictions, and put together an informational report for the legislature and the governor to let them know, it's like, here's the universe of possibilities for how states address emergency response. Here are sort of the policy pros and cons of the different possible approaches. So Kristen has been doing a lot of background work on that. It has not required commission decisions. We have another piece of it on the agenda today. In November, I think that Commissioner Carrillo, the chair's Center on California Constitutional Law, I don't remember the name, I'm sorry, is assisting us. They're going to be preparing a report on some of the constitutional issues involved in emergency response. That'll be on the agenda, I hope, for November. So there's a good chance we will be wrapping up the information gathering phase of that by the end of the calendar year, and that all that will remain for 2023 is putting it into a report form. So not a lot of staff work for that, because we have the information, we just have to express it in a useful way, condensed way, and not a lot of commission time. Again, assuming you're okay with the report that we prepare, it shouldn't require much discussion. So a little bit of work in 2023 on that. And then once that's done, you'll have to decide whether you want to open a new front on the broad topic of emergency response law, or put it on the inactive list until we have a little bit more slack in our resource picture. I think the latter is what I would recommend, but we can make that decision when we get there. So again, I'm not expecting necessarily to have a lot of work on that topic in 23. Stock cooperatives and revocable transfer on death deeds, we're pretty much done. There's legislation that's going to need to be introduced, but there's going to be a legislative program behind all of this. I'm concentrating on study work and commission deliberations. So stock co-ops is effectively done. State and local agency access to customer information from communication service providers. We have just one significant topic left in that quiver that has been inactive this last year, and it has to do with minimizing the interception of privileged or irrelevant materials in conducting a search of electronic records. There is a good, well-developed process for that when you're doing wiretaps. You turn the tap off, you wait 30 seconds, you turn it back on and see if it's still privileged. As we've discussed in the past, that's not really practicable when you're dealing with a whole bundle of email or text messages. You don't like stop reading, wait 30 seconds, and then read the next one. There's no analog. So we had talked about whether it might make sense to require compartmentalization within the DA's office, or some kind of special master or something like that. It's a big project to bite off. There's no deadline on it. It's not a direct legislative assignment. My recommendation is we continue to keep that on the inactive list until we've got more resources. Also, it's kind of not the best time to be entering the fray about special masters and search warrants and subpoenas and what records you can and can't look at and that kind of thing. It's got a political tone to it right now that would complicate things for us if we were to study it now. Statutes made obsolete by trial court restructuring. There's a little bit of work potentially that's left over. At the last meeting, you approved a minor proposed change, the repeal of an apparently obsolete section, and with the understanding that it would eventually be put into a tentative recommendation. That could be done, could be put into a tentative recommendation. We could consider comment on the recommendation, etc. Not a lot of work. I think it's something that could be done pretty simply. So, but beyond that, there's nothing else that's currently served up on trial court restructuring. At the last meeting, there was a commissioner suggestion that possibly we make an informed assessment about how to wind up that study entirely. And I think eventually that would be useful to do. I don't think that's a high priority because the study's going to be sitting on the inactive list and not causing any complications for us there. And, you know, the understanding could be that the next step after reactivation would be that overall assessment of the remaining of work and study. So bottom line for 2023, potentially a little bit of work that would be pretty easy to do, not much. So yeah, that's the good news, is that the active studies are winding down, and we're going to have some slack in our resources because of that. However, moving on to the next major heading, pending legislative assignments, we have got a lot. The first is ACR 95, Cunningham and Wicks. This is the study of antitrust law. It's been approved, and because it's a concurrent resolution, it's effective immediately. So on chaptering, and it's been chaptered, we now have legal authority to study this topic. I'm already starting to get some inquiries about it. I think that once we formally start, there's going to be like a lot of pressure on it. I think it's an enormous topic in both breadth and depth and complexity and political implications. So this, I think, is going to consume an enormous amount of our resources going forward. It's going to be one of our major commitments, I think. As I explained in the memo, we do not have staff expertise on this subject. And that's going to be required because, you know, like I said, this is an enormously important and difficult topic. One of the things that I proposed in the memo and that I recommend is that we contract with subject matter experts to serve as consultants so that they can ideally provide us with a written background report that summarizes the law and the areas that are under scrutiny for reform, and can also attend our meetings and, you know, answer questions as necessary. We've done that in the past, but it's been a long time. It's probably been 15, 20 years since we've had a consultant with that kind of a relationship. We have the funds available because, as I mentioned at the top of the meeting, our former chief deputy counsel's position is vacant and will remain vacant for a few more months. That frees up a lot of money that can be repurposed. So if we act before the end of the calendar year, I don't see any difficulty having sufficient funds to provide an honorarium to consultants. I'm thinking in the range of $5,000 to $10,000, depending on the commitment. I think that's in the neighborhood of what we've done in the past. It's, you know, enough to compensate them for the time that they'll spend, but not commensurate with what the market would bear. So it's kind of a compromise between a pure honorarium and compensation. The way that this has been done in the past, and I have never done it, but I have seen it done, is that the staff sort of combs the universe of potential candidates, talks to them informally about their interest and availability, puts together a pool of names, and then brings it back to the commission. And then the commission votes to approve the contracts or not approve the contracts. So the selection process would finally be in your hands. One of the things we're going to talk about next is the meeting schedule and whether or not we have an October meeting. And I'm disinclined to have an October meeting, in part because I would really like to concentrate during the remainder of this month, the entirety of October and early November, on coming up with a pool of candidates for you to consider, so that at the November meeting, you can decide whether to contract with any of those consultants, and we can start their work going. It's once those decisions are made, then they're going to be doing a lot of work that's offline in preparing whatever materials they're going to provide to us. And so the necessary predicate to the commission's deliberations will be in progress, but it won't require much staff time or meeting time until they're ready to submit their work product. So that's how I'm planning to proceed with the consultants in that study. The other thing that occurred to me is that you know, I've been sitting in all the meetings of the Committee on Revision of the Penal Code, and they have been using from the beginning, they have been using a different model for how they sort of conduct the main body of their meetings, which is that they've been having these panel discussions. So at a typical committee meeting, they will invite panels of experts, and sometimes they have 2 or 3 panels in a single meeting. It gets long when they do that, but typically 3 panelists per panel who are experts in a particular subtopic that is before the committee, and who sort of represent at least something of a range of perspectives on the subtopic. And those folks come in, and they could be anywhere, right? Because they were doing Zoom meetings, so they could, their location's irrelevant. So you can find experts from across the country who then make brief they submit in advance some written materials summarizing what their presentation will address. Then they make a brief presentation sort of summarizing their writing, and then there's Q&A, where the committee members have a chance to ask questions of these experts. And the purpose of that is educational, which I think with respect to antitrust could be really useful. Educational and illuminating. That I think the Q&A is helpful because, you know, sometimes things that they say cause you to reflect on it in a different way or see something that you hadn't understood before. And so immediate follow-up is kind of handy as compared to just having a written record that you read and then talk about. So this is kind of a hybrid discussion because I'm talking about work priorities for 2023, but I'm also talking about sort of how that work could be conducted, because I think it's going to affect the staffing. If we, in November or December, authorize some consultants, then we can get them going, like I just said. But then the other piece that I was thinking is that it might be helpful to, starting in January of next year, look to begin this sort of educational panel process that I just outlined, if that sounds useful to you. And it would just be a component of a regular meeting. We would just, in connection with antitrust, we'd say, okay, we've got 3 guests today. They're going to talk about this aspect. And then once that concludes, we'd move on to the other studies. I am going to cheat ahead a little bit and say that all of what I just said about antitrust is also true of the Equal Rights Amendment study, which is the next item that was authorized by the legislature and is now legally operative, and we now have authority to take on. We have, Kristen and I already had some really helpful meetings with stakeholder leadership in that area. And I think that on that one, it's going to be like drinking from a fire hose. I think there's going to be an enormous amount of information, and stakeholders are going to be extremely happy to educate us about their understanding of what's helpful and necessary in California on that topic. You know, it's equal rights, it's equal protection of the law. So as lawyers, we have some familiarity with that issue, but we probably do not have the sort of deep knowledge of how equal protection manifests in connection with sex and gender that these stakeholder groups have. And so I think it would be helpful to try and do the same sort of thing, pull in some consultants and ask them to prepare background materials for us and serve as consultants at meetings, make themselves available to answer questions. And then also perhaps do some of these panel presentations so that we can include stakeholders from around the state, especially before July 1, when we turn back into a pumpkin and maybe can't do Zoom meetings anymore. So I think it would be helpful to sort of front load this stuff in the first half of 2023, try to, at each meeting, have a panel. It might make sense to alternate the studies if we're having monthly meetings, January antitrust, February ERA, March antitrust, etc. And that would give us, I think, a good running start at these really broad, complicated, important topics to ramp up our knowledge of the issues. And, like with antitrust, like I said, I've sort of dipped my toes into the background on that and the issues. It's huge, and I really think we have to have a process that's going to help us to get knowledgeable enough to usefully talk about it. And speaking for myself, I cannot usefully talk about the topic yet. I don't know enough. Whereas I think if we get a good background report or more than one, and we have a series of special or stakeholder and expert panels, then by the middle of next year, we maybe will be in a position where we can start deliberating. I see a hand from Commissioner Huebner.
Yes, I don't want to jump ahead and comment on any of this, but I have a question about the genders, the sex study you were just referencing. Being new to this iteration of the commission, I don't have familiarity with the origin of this project. Is it clear in the materials that have come to us that there is a clear definition of sex? In other words, is the presumption that the project is about the Western binary definition of sex as either visually male or visually female, or is it ambiguous what sex is intended to mean?
Right. Is it chromosomes or is it a social construct, right? I asked that question. The meeting that Kristen and I had were with the high-level staff of the two organizations that sponsored the resolution that gave us this study. And it was their sense that the two could not be separated in the study. I think it remains to be seen for us to learn more about the topic, especially because it's grounded in the Equal Rights Amendment. And that is language that was drafted in the 70s, and all the ratification that has been going on since in the various states is of that old language. I don't know for myself. I saw the same question. I don't know. And they were quite confident that the two issues are so tightly interwoven that they would both be before us. I have no objection to that in principle. I'm always just careful about making sure that we have the legal authority to work on a topic before we work on it. And this is our sole grant of authority for this subject area. So I think that'll be one of the early issues that we'll have to decide is the scope of the study.
Yeah, and I don't have a point of view. It's just definitionally, Pacific Island cultures and many other indigenous cultures have a third gender. It's not a binary gender environment.
Mm-hmm.
And we have at least one or two US Supreme Court justices who view sex more expansively than just male or female in how they interpret non-discrimination laws. So I think having some clarity around what we're really interested or authorized to study would be important on this one.
Yes, I agree. And I think that that will be an early question for how the work proceeds. It will be to set the scope boundaries on it. In terms of its origin, you said, you know, you were not familiar how it came to us. It came to us by surprise last year. I don't know the history. I didn't ask how it evolved into the form that it's in. But I was approached by staff from the senator's office who authored the resolution, Senator Leyva, and was told that they were contemplating doing this. And, you know, I gave her the answer that I give everyone who makes those kinds of approaches to me, which is great. You know, we study things the legislature wants us to study and authorizes us to study. If you want us to do this and you authorize it, we'll happily do it. And that's about as much input as I ever have into these things, except that I do like ask about deadlines. You know, I explain that we're very busy and that if you put a strict deadline on it, that may create problems in the appropriations committees. If they're asking me like, can you absorb this without an additional appropriation? I always say, if there's no deadline, yeah, we can. Although we're sort of at the limits of that, I think. So yeah, I wasn't expecting it until it happened. I don't know whose suggestion it was that the Law Revision Commission was the entity to do this study. But I'm happy to have it. I think it's going to be extremely interesting and potentially useful. I mean, both these, that's the thing, the antitrust study and the Equal Rights Amendment study, I think, are atypical for commission work in that I think that either one of those could have national implications, that whatever we wind up doing could become a model for other states. Now, that has happened with commission work in the past where we've done sort of comprehensive treatment of studies that were of topics that were jumbled up and other states wound up borrowing California's approach. But I think this one just could be much more immediately important beyond California. That's part of what we heard from the stakeholders, was that there is not yet a state that has enacted a strong ERA implementation. There are a couple of states that have done it in more modest ways, but that they're excited about the prospect of California setting a national model. So what do people think about the initial proposition that these studies become top priorities for 2023 before we go on? Okay,
See lots of nods.
Not seeing any dissent from that. How about the plan that I've outlined for how to sequence the early stages of the work in terms of bringing you a slate of potential consultants for consideration in November or December, and then trying to set up informational educational panels for the meetings in early 23.
Sounds good. Okay.
All right. We're going to fold all that into a final motion at the end of the presentation of this memo. I was going to do this morning and I didn't, so maybe I'll do it while I'm talking. If I can pull this off. The other legislative assignment that was sent to us this year is asterisk that was proposed for us this year is AB 2503. I believe it came to us as initially being a substantive bill that was considered by the Judiciary Committee and in the Assembly, where the author of the bill had proposed making changes to the terminology used to refer to lessors and lessees, landlords and tenants, in a number of statutes to create greater uniformity. The Judiciary Committee and the author jointly agreed that a better approach would be to refer it to us for study. And so the bill was amended to do that. It has passed out of the legislature. it is before the governor. I just checked, and at least according to Kara's website, it has not been signed yet. And I don't want to put you on the spot because I can never remember the details of these rules, but I believe that the general rule is that there's a certain number of days after the legislature passes a bill that the governor has to sign it.
Viceroy?
I
30 days.
don't. How many?
I believe, I think it's the end of September. Yes.
Yeah, I just pulled up the legislative calendar and it says September 30 for governor's signature or veto.
Well, is that all it says? Does it say something about for bills sent to the governor that were passed by the legislature before?
Yeah,
a certain date?
before September 1, that in his possession after September 1, he'll have.
Okay, so this was, I'm looking at the history, passed in the Senate August 24, enrolled August 29. So I don't know for the purposes of that rule, whether it's passed or not. Anyway, we're getting into the weeds. It's not yet clear to me whether this will be a study in 2023, but or whether
According
it's,
to LAS, it says that it was enrolled and presented to the governor on September 6th.
Right, but it was passed by the legislature before the 1st of September. It's in the governor's possession after the 1st of September, which means he hadn't signed it yet. That's he still has it or hasn't vetoed it. So he has till the end of September to sign it.
okay.
Right.
Yeah, I couldn't parse the rules and be confident that I knew how it worked. So I didn't know whether this was still a live vehicle or whether it had been subject to some kind of veto through inaction.
Brian, given the two large studies that we definitely have on our to-do list, does this sound like something that should maybe not be on the back burner, but lower down below those other two things?
This one has a deadline. It has a 2-year deadline. I asked for a 2-year deadline when they talked to me about feasibility.
Can we at least wait until like the end of 2023 to pick it up?
I think so.
It looks like it's a smaller study, so it shouldn't take 2 years.
Yeah, that was my thinking too. Was that 2 years would be ample. So certainly I have the same sense that this is a less demanding and less high priority study than the other two I just mentioned. I think we have to hit the ground running with ERA and antitrust. I think we could drag our feet a little bit on this one and still meet the deadline. So the last important piece of the puzzle has to do with inactive studies. Okay, so we did this work on recodification of the toxic material statutes, and we completed a recommendation, I think in 2021. And we had implementing legislation introduced this year. And then we set the study aside. The study directed us to recodify 2 different chapters of this specific statute they were concerned with. Our proposal that was put before the legislature this year sort of did the low-hanging fruit. It did and Kristen can correct me if I'm wrong, but the easier of the 2. Because we wanted to test the waters. We've been running into this problem with Fish and Game not wanting their statute recodified and resisting it. We didn't know what to expect out of Department of Toxic Substance Control, whether they might take the same adversarial posture once the bill was in the legislature, in which case, if we wound up not being able to enact the easier piece, then there's be no point in struggling with the harder piece. So it was set aside for potential reactivation once we knew whether the easier piece was viable. So it is viable. The legislature passed it this year. We just in the interval between the last meeting and this one, it's been chaptered, it's law now. So there is appetite. It was not opposed, although I think DTSC went into appropriations and said it was a cost item for them, but that wasn't enough to obstruct it from passage. So it's been passed. This is a legislative assignment that was given to us a couple, 3 years ago. It's not as sort of high profile and flashy, but it is a legislative assignment, and we did make a commitment that we were going to return to complete the work once we had confirmation that there was appetite for the work. And we now have that confirmation. So I believe that while we could postpone it, and we probably wouldn't get a lot of heat for that, I think this ought to be our next priority, below the things I've already talked about. To the extent we have the resources, I think we should return to this and try and wrap it up. So that completes the picture of what we have in front of us. I should say, I already said, I think we should continue to postpone work on that little piece that I had about minimization of interception of privileged material when you serve a subpoena, etc. That one can wait. Nobody's waiting for that. But the rest of the stuff, I think there are people who are waiting for it. The toxic subject, before that was assigned to us, I got invited to a meeting with fairly senior people in legislative staff who, they want us to do it. It was their idea, and they asked, and we said yes. So my recommendation would be that 2023 ought to be dedicated to antitrust, ERA, finishing toxics, and if 2503 is passed, and if resources are available, we do 2503 in 2013 too, with the understanding that that one at least has a longer run out, and so we could put it on a slow track and postpone it if we decided that we don't have the resources to keep all those balls in the air at the same time, especially because we're down a senior attorney position.
And we're
So
going to be
that-
missing Brian.
Yes.
Any discussion on that? I see no hands.
So is that acceptable as a priority scheme for 2023?
Sounds good to me. I'm seeing nods.
I'm going to call the roll on that. Again, not calling absent members, alphabetical order. Carrillo,
Aye.
Carrion,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Good. That's the plan. The other thing I wanted to ask about in connection with this memo was the memo itself. The form of the new topics memo that I inherited from my predecessor that had been used 20 plus years, ever since I started in 96 is what the format that they were using, was much more bulky. It included a very sort of exacting walking tour of all of our authority, all the things that we're working on, all the things we might work on, all the things people propose that we work on, etc. And then it wrapped up often, especially more recently when we're just so jammed up with legislative assignments. It usually wound up with like one page at the end and saying, but despite all that, we don't have the resources to do anything other than the active studies and the new things the legislature assigned. Is that okay? And so they were like 60-page memos that boiled down to about one page of, we don't have any discretion, so let's just do the mandatory stuff. And I've been trying the last year or so to do a little bit of house cleaning in terms of admin processes and things like that. And this was one of the things that I've had my eye on for a while as an instrument that could be simplified. And so one of the simplifications was to move a lot of the historical information into appendices so that they're not cluttering up the memo and you don't have to read them year after year after year before you get to the stuff that really matters. And then the other thing is just to just really simplify the presentation of like, here's what we're doing, here's what we have to do, here are the things that we could do. What? tell me what to do, right? So it's much shorter and more pointed. And like I said, a lot of the material's been moved to the appendices. Did anyone have any concerns or suggestions about that broad repackaging?
No.
Okay, so the other issue that I think is worth talking about is the treatment of the appendices. What we've got in the appendices is, the first one is a rundown of our existing authority, and I think that's useful. I'd say let's keep that for sure. It's just like what's in the current resolution, what statutes are in operation right now that assign us or authorize work. So that I think is a useful reference for this document. Exhibit 2 is the back burner list, and Exhibit 3 is carryover suggestions. So the back burner list is things that the commission has previously like started to work on or expressed as a firm interest in working on, but we haven't worked on it for many years, and the prospect of it rising to the top of our priorities is low because the legislature keeps giving us new higher salience work. So these documents, there's no mechanism to purge them. They just accumulate. And to some extent, it's unhelpful. To some extent, I think it doesn't look great for us to be reminding everyone, here's all the things that we didn't get done, right? And so one piece of what's in the back burner list, I think, is necessary and important, which is I'm using it to memorialize remote deadlines. We have now this assignment to return to do a final look at revocable transfer on death deeds in 2029. And I want something that's going to be in the executive director's face every year to help them remember, like, don't forget, 2029 is coming. We used to have another one. We recodified the rules on enforcement of judgments. And part of that was the commission had a decennial review duty every 10 years. We got rid of that. But if we hadn't, that would go here too. It would be like, remember, decennial review, next one's in 2025. So I think that's useful. I'd like to keep that. The second section of this exhibit is topics the commission might eventually start or restart. And this is just turning into sort of an elephant's graveyard. And I would propose that we trim it way back. We can footnote later versions of this memo to say, if you want to see what we used to have on this list, go look at the old memos.
Brian,
so
do you feel like you need authorization from the commission to do that? That seems like an administrative thing.
Well, it's just like, this is a pretty wholesale, well, okay, two things. One is this general conversation, I've done a wholesale reformatting of this, and I want your buy-in. I don't know if I need your votes, but I want your buy-in and to know that I'm heading in the right direction. With respect to this actually reflects the commission's prior decisions that these are topics that it might want to return to in the future. And so I feel like it might be in excess of purely administrative discretion for the staff to say, yeah, we're not doing that.
Does anybody want to make a motion to cut
Well,
that from future
Let me
versions?
refine it just a little bit, which is, there's two topics on here that I would recommend we keep. And I'll explain why. One is under discovery, that has a split date, 2017, 2009. 2009, we got a background study from Professor Weber, all kinds of thoughtful ideas about how to improve discovery statutes. We never have really acted on that. But in 2017, former Commissioner Capizzola came to us and proposed a study topic. And it was briefed in a memo to the commission. And the commission specifically said, let's postpone consideration of that topic because there's this bill that just got enacted that enacted a study, like a pilot project of informal discovery conferences. We'd really like to see whether that statute sunsets or is extended by the legislature before deciding whether to work on this. So that statute just sunsetted this year. So our last expression on this topic was, we will come back and think about it again sometime after 2023. 2023 sunsets on January 1. So I'd hate to knock that off the list, because I think that it's something the commission actually made a decision that it would reconsider at some point.
So can we get a motion to delete everything other than those two things off of the
Well, one
graveyard?
I haven't said what the other one is yet.
I thought that was
which
two
is-
things.
There is two things. The other one is that some years ago, a Court of Appeal decision included a suggestion that the statutes on civil venue are really hard to use, that they need to be cleaned up. And they proposed a suggestion that Legislative Council, I think they called out Legislative Council and said, you should perhaps look at this, in their nice, not overreaching way that they have. And Diane Boyer-Vine, then Legislative Council and member of the commission, brought it before the commission and said, this feels more like it would be work that would be appropriate for the commission than the Legislative Council, because it's fraught and technical and substantive. It's the kind of thing the commission is good at, and the commission agreed. We did not have statutory authority to study that topic. So with the intention of working on it, we asked for authority to study it, and the authority was granted. And then our resources kept being jammed up with higher legislative priorities, so we never started it. But this is one where we actually went to the legislature and said, would you please authorize us to do this, because it's something we're interested in doing. So sweeping that one away, it could be done, but it felt to me like it was in a different class than the others, and might be worth keeping it around until, against the possibility that someday we have the resources.
So anybody want to make a motion to delete everything other than those things from our running list? Sochi has her hand up.
So
Second.
moved.
It's been
Second.
moved and seconded. Let's call the roll.
Carrillo,
Aye.
Carrion,
Aye.
Ebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Thank you. The last point I'll make about this memo, I don't think requires a vote. It's again in the zone of, I just want to make sure we're on the same page. The other thing we've been doing, which is expressed in the Exhibit 3, is this year we didn't get any new topic suggestions worth discussing. Most years we do. Most years we get 2 or 3 things. And the memo includes a discussion of those. Sometimes the commission's response to those suggestions is, that's a really good idea. There's no way we can work on this right now. Staff, please bring this back to us next year and remind us of it so that we can consider it at that time. And so at the staff level, we call those carryover suggestions, right? They were previously briefed. Here they are again. And so that's what's in this appendix, or this exhibit, is the suggestions from prior years that we've been carrying over. There is no process for purging this list either. And so it grows unless we purge it. The staff position is that we could purge everything that's in this exhibit right now. While they may be good ideas, it's just not going to be possible for the commission to work on them in the foreseeable future. These folks shouldn't be led on to think that we might work on it. They should go look for other remedies. And so I would suggest, with respect to the specific exhibit, that we not carry these items over in next year's new topics memo.
Do we need a motion to purge?
I don't think so. I think that this is just administrative, because, as long as I have the sense that no commissioner has any objections about not carrying any of these items over, I think we're just going to let them go. And then There obviously there won't be anything carried over to next year because we didn't have any new ones to present. But after that, we may need to revisit the carryover practice because I think it's kind of a, sometimes it's kind of a fiction. And we can reevaluate whether we want to sort of impliedly promise that there's a meaningful chance that we might return to topics that a lot of times there's just no meaningful chance. So with that completes my presentation of this memo. So you approved the priority scheme that we discussed. You approved purging items from the back burner list, except for the two that I noted as having continued relevance. And then I got the general sense that you're fine with the approach in the memo and that I'm not going to carry these Exhibit 3 items over to next year. Okay.
Before we move on, can we take 5?
Yeah.
Can I ask a quick question about the memo? Does the memo is it published in our minutes?
Yeah, it's on our website. It's part of our permanent public facing record, and the decisions that you made will be in the minutes.
Okay, I just have one comment about the Exhibit 2 naming it the back burner list. I feel like it has a negative connotation for our work, and I'm wondering if there's another, like, future studies or some other way we can capture that.
Yeah, some staff agree with you. Yeah, it's just a term we've used historically, and I think that having heard that strikes you that way, I see no problem with recasting it, and we'll find a less something with less of a pejorative implication to use in the next version.
That'd be great. Thank you.
Okay. Okay, if you're taking 5,
We're taking 5.
I will try to put up some kind of a notice that we're out, but everyone be sure to mute and turn off your cameras. I've had on the committee side, sometimes we accidentally pick up conversations people didn't know they were broadcasting to the world. So thank you. Commissioners are all back. Looks like, yeah, it looks like everyone's back. You want to reconvene? Oh, no, sorry, Victor tricked me with his, there we go. Meeting schedule? Okay, so this is memo 2243. It has two main components to it. One is whether or not to schedule a meeting for October 20. And I think I've said earlier, I would recommend against. I don't think we'd be able to put together enough material to justify the imposition, and I'd rather have a longer interval to pull together the slates of potential consultants for consideration at our November meeting, November 17th. So the first decision, which is leave well enough alone, I don't think I need a vote on it, but I would like to hear whether anyone sees it differently and wants to hold the meeting in October. Nope. Okay, we'll do that. And then the second question has to do with the proposed meeting schedule for 2023. The main feature of it is that it presumes we're going to lose the ability to do Zoom meetings on July 1. So January, February, March, April, May, June are all month intervals. And then after that, we go back to every other month. And similarly, the Zoom meetings, the more frequent Zoom meetings are morning only. The longer in-person meetings are the better part of the day, before and after lunch. So that's the general structure. The devil's in the details, so I need to know whether anyone sees any problems with the specific dates. Excellent. Okay. So that one I would like a vote on. If you're comfortable, I would need a motion and a vote if you want to approve that as your schedule for 2023.
So moved.
Second.
Moved and seconded.
All right, I will call the roll on that. Carrillo,
Aye.
Carrion,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
McAllister,
Aye.
Simpson.
Aye.
Okay, thank you. That's all on that item. The last memo I have is 2244, the legislative program update. This is effectively the final update of the year because all of the commission's bills to implement commission recommendations have been enacted and chaptered. So a successful year for us. And as I've already mentioned, we were keeping our eye on 3 measures that would assign us new studies. 2 of those ACR, I'm sorry, I'm going to blank. 2 of those have been approved and are now operative. That's the Antitrust and the Equal Rights Amendment. The other AB 2505, I believe it is, I don't have it in front of me, is awaiting the governor's signature. So everything's done except for the resolution of that last item, and we're just waiting to see. I will report in the next executive director's report at the November meeting what happened with that proposal. Purely informational memo, no decisions required. You have any questions? Then that is done too. And I am done.
Next agenda item, number 5, emergency related reforms.
Good morning, commissioners. Yes, so memorandum 2022-45, which is before you today. First, I just want to acknowledge looks a little bit different than what you've previously seen in this study. So the prior memos in this study have focused on presenting comparative analysis of different approaches taken in emergency laws across the states. As staff started approaching the issue of spending and fiscal related emergency issues, we quickly realized that doing that approach in this case did not seem like it was going to really present a complete picture to the commission, and was going to be complicated for a number of reasons. So as the memo discusses, emergency spending is often made up of several different mechanisms. So the memo summarizes a report prepared by the Pew Charitable Trusts that does actually look at comparatively across the states, how states are funding their, they looked at what was called disaster spending, but that report was prepared and actually finalized just as COVID was kind of ramping up. So they were not looking at it in the context of a public health emergency, but disasters more broadly. So what they found is essentially that there are 5 different mechanisms that states use. Some of those mechanisms are money set aside in advance of the emergency. So that can be either a sort of designated emergency or disaster fund, or a general reserve account that can be accessed in emergency situations as well as other situations. And then there are things where you can respond to the emergency, like supplemental appropriations or providing transfer authority. And the last category was using state agency budgets, which can be used both as sort of a proactive way you can allocate money to agencies to deal with emergencies ahead of time, but also those budgets can potentially be accessed and sort of changed after the fact as needed to deal with emergencies. And essentially the memo describes what Pew found. Most states use a combination of those mechanisms, and California uses actually all 5. I think all states use at least 3, I believe. Don't have the numbers in front of me, but the pots of money that are being used and accessed for emergencies might have different rules. So depending on where your spending is coming from, you might be looking at an account that has certain rules. And those accounts may not be found in the state's emergency laws. Some of these things would occur entirely outside of the sort of general state's emergency law. The report also discusses federal funding, which is a big part of emergency funding, and often states' emergency laws do have some provisions related to federal funding and how that can be used. There's some discussion in the memo about California. There's a special provision that's included in our budget that provides some authority to spend unanticipated federal funds if you meet certain conditions, but otherwise the state does not, I guess the governor does not have the authority to spend those funds. So some of this actually can occur through the budget and what they call control sections in the state budget. I guess I should take a step back. I want to acknowledge that this is an area that I am relatively new to, and I actually got a lot of assistance in sort of coming up to speed from the LAO staff and Commissioner Simpson. So I just want to thank them, but also say any mistakes in this memo are my own. But there was a lot of sort of background material to learn about, and the memo provides some context, but a very high level because there wasn't a lot of time to sort of dive into the depths, and you can very quickly get into the depths on fiscal issues because they are really their own beast, I think. So turning back, in addition to the Pew report, which is sort of summarized in the first half of the memo, the staff also found that the Legislative Analyst's Office prepared a report for California specifically for the 2021-22 budget that talks a lot about COVID spending and what had been happening and some of the things that were being proposed. And that report actually makes several recommendations about how emergency spending generally could be reformed, and with an eye towards improving legislative oversight. So the report talks about the California Emergency Services Act, which is what we've focused on to date, how the governor has used that authority. And there's another law, the California Disaster Assistance Act, which sets up a fund. And actually the governor has used for the most part, the governor has used Emergency Services Act authority to transfer money into this other disaster fund. And that fund, once the money is in there, has certain rules about legislative notification. The report makes clear that that process is currently, there's not a really clear legal requirement to do that, but the report recommends that that process be required, and also make some additional recommendations about legislative notification and reporting to sort of improve on what they saw. Essentially, when staff got to the end of this, we concluded that, you know, trying to figure out, just looking simply at the emergency laws was not going to be sufficient and not going to provide the report much in the way of explanation of how emergency spending actually worked. Operationally, I think emergency spending is much more complicated than the provision in the Emergency Services Act would suggest, because you have to be thinking about, you know, accounts that are set up in other laws, things that are happening in the budget, et cetera, and trying to do a comparative analysis across all of those is a much more complicated endeavor. So at this point, the staff is recommending against pursuing any sort of comparative analysis on this issue, but wanted to present this information to the commission so that you were aware of sort of what was out there, and offer to answer any questions that I can. But like I said, my knowledge of this topic does not go very deep, and I'm happy to, you know, expand on this going forward as a commission sees fit. So if there are any questions or comments, I'd welcome those from the commissioners.
Any discussion?
I thought it was a good summary.
Thank you. It was like I said, a complicated area to sort of come up to speed on quickly. So I hope that I touched on sort of the key points without overlooking anything critical. So
Seeing no further discussion other than a thumbs up from Jane. Anything else on that, Kristen?
So the only thing that I would mention, I think Brian mentioned earlier that we're going to be seeing a white paper coming in from the California Constitution Center discussing some of the constitutional issues around emergencies. And I expect that will be coming up for the November meeting. Otherwise, the main thing to deal with going forward is just the different ways to terminate an emergency and how that works across the states. And I believe that should be a much easier and straightforward comparative analysis. So I expect that would be presented the same as the prior materials. Also, just to mention, since the legislative deadline is coming, or the deadline for the governor to sign bills is coming up, we'll have a better sense of whether there's been any changes to the emergency laws, and we'll be turning to look back at that and letting the commission know about that too.
Sounds good.
All right.
Seeing nothing further. Thank you, Kristen.
All right.
Let's
Thank
move
you,
on to
commissioners.
Our last agenda item, number 6, Fish and Game Law. I think that's Steve.
That
Steve,
is right.
you look a little
Thank you.
blurred.
Oh, I'm sorry. I was playing with my background.
Yeah.
I don't know if, let me see.
It gives you that, like nylon over the face. I'm about to
I will
rob a
try.
7-Eleven
Let me
look.
try. I'll try this other one. I don't know if that's any better. Now you have light over my head, but maybe I'm a little clearer. All right. So good morning, everyone. As Brian indicated earlier, in this study, we are moving slowly, but inexorably, hopefully, to a final recommendation that would amend a great number of sections of the existing Fish and Game Code. We started with a tentative recommendation some time ago, a mammoth tentative recommendation that had a number of proposed revisions that would have created a new proposed Fish and Wildlife Code, but that has changed. So we now have over 100 amended sections that have been approved, and they're all in your Memorandum 2247. We are adding more. There's a few more proposals in 2246. There was only a small amount this month because of the short meeting interval. And there's also a sort of I guess a little bit of a backup with Fish and Wildlife. They're working with us and being very helpful in giving final approval to language of existing sections to make sure we haven't missed anything. But they have a number of different staff counsel who work on these revisions, and there's been some turnover. So there was a little bit of a delay, but I'm really hopeful that in this next meeting interval, we will have many, many more to present to you. So what you have today is a hopeful approval of the recommendations, the staff recommendations in Memorandum 2246. As we've done in the past, we've asked for approval in the aggregate of all of them after an opportunity to comment or ask any questions, either from commissioners or from anybody who might be present at the meeting in the audience. So anybody have any questions or comments or issues?
I would just say that looking at the audience, there is no one other than our own staff there.
Okay. They probably don't have any comments either, so, okay. Okay, then I need a roll call, I guess, or I'll give you a roll call, but we need approval then of, or motion rather, to
Can I get a
approve all
motion?
the staff
Move
recommendations.
move approval of the staff recommendation.
Anybody second?
Second,
The ambassador seconds.
Excellent. Roll call. Commissioner Carrillo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Hebner,
aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Simpson.
Aye.
Excellent. Thank you very much. I hope to give you a lot more at the next meeting. Thank you.
Does that complete our agenda?
We are done.
Super.
Thank you, everyone. And we'll see you in November.
In November.
Thank you.
All right. Bye.
Bye, everyone. Have a great rest of the week.
You too.